Good afternoon. Welcome to our program today entitled Surviving a Governmental Investigation Without a Black Eye, Key Legal Communications and Crisis Response Considerations for Nonprofits. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And as many of you know, this is part of the monthly series that we've been doing for over 3 years now on nonprofit legal topics here in Venable's D.C. office and broadcast around the country via webinar for those that can't join us in person. We hold the programs here once a month. We offer lunch here from 12 to 12:30 p.m. Eastern for those who can join us, and then the programs run from 12:30 to 2 o'clock. Today's program is co-sponsored with Ogilvy Public Relations. As some of you know, some of the programs that we do here at Venable, we do with just our Venable lawyers, and sometimes we partner up with other firms and organizations and speakers who have interesting and important contributions to make to the topic, because as you know, many of the topics that we deal with certainly have legal implications and legal aspects, but have many non-legal considerations as well, and today's topic lends itself quite well to that. And so we've partnered with one of the nation's premier public relations firms, Ogilvy, that has a lot of experience in working with nonprofit organizations and for-profits in connection with governmental investigations. It's been a great experience working with the folks at Ogilvy to prepare for the program on our program today, and I'm no doubt you're going to very much enjoy it. A few other logistical and administrative things to deal with first before we jump into our speakers and today's program. First, a preview of some of our upcoming programs. These two listed on the slide here are available for registration now if you're interested in signing up. On June 18th, next month, our topic is entitled Performance Management and Discipline in Nonprofits, Common Pitfalls, Unique Challenges, Effective Solutions. This is going to be a terrific program. Probably about twice a year we devote the topics for our nonprofit legal seminars and webinars to employment-related matters. There's never a shortage of interesting, important, and difficult to deal with topics. This is one of them, and a couple of my colleagues, Dave Warner and Megan Mann, will be leading the discussion for that program, which I hope you can join us for. And then the month after, on July 17th, our program will be entitled Key Trademark and Copyright Rules for Nonprofits to Follow and Break. At least once a year, we cover intellectual property topics, primarily copyrights and trademarks, which are always important issues for nonprofits to have to deal with. I'm going to be joined by two of my colleagues, Andrew Price and Justin Pierce, who do extensive work with our nonprofit clients in the trademark and copyright area. This is always an area of great interest and a lot of interesting, difficult issues, and it's going to be a terrific program. And then we actually have our August and September programs scheduled. They're not available for registration yet, but they will be soon. On August 13th, our program will be entitled Privacy and Data Security for Your Nonprofit, Understanding Your Legal Obligations and Insuring Against Risk. And on September 16th, our program will be entitled What's Ahead for 2015, Preparing Your Nonprofit's Group Health Plan for the Employer Mandate. A few things about today's program. We encourage you, because of the nature of the topic that we're going to be discussing today, to ask questions throughout. Sometimes we can do this, sometimes we can't, but with the nature of today's topic and the volume of material we have prepared, we think it's going to be a much more rewarding and enjoyable program, and you're going to get a lot more out of it for all of you if you actively participate throughout the program. So we ask you to ask questions throughout. For those of you in the room, wait until the microphone gets to you. There's a handheld mic that Marion will be walking around with so that everyone on the phone can hear the questions, poses to our speakers. Our speaker is going to speak from the podium here today, but feel free to pose questions to any of our speakers who may be seated at the table as well. And those of you on the webinar, pose your questions to me via the chat feature on the webinar software, and I'll pose those to our questions at the appropriate time. We'll also likely be posing questions too and interrupting each other, and we really hope to make this a very interactive program today, so we need your participation in that. Those of you here in the room have a printed bound booklet that has copies of today's PowerPoint slides for the presentation, along with our full speaker bios and some related ancillary articles and handout materials from both Venable and Ogilvy. Those of you on the webinar should have received an email copy of the slides, and tomorrow all of you will receive an email that contains a link to all of those materials, both the PowerPoint slides, the bios, and the related articles and whatnot, along with a recording of today's program, which you should feel free to share that email with colleagues and others who may benefit from today's presentation. And as some of you know, we have now posted and we host all of the recordings of our monthly nonprofit legal seminars on a special Nonprofit Venable YouTube channel that's easy to get to from our website or elsewhere. And there are links to all of our recorded webinars and other hundreds and hundreds of articles and presentations on different nonprofit legal topics on our website. The links are available on the last slide in today's PowerPoint presentation. Now, brief introductions of our speakers. I'm not going to spend too much time because I want to get right to the heart of today's program. Our first speaker, James Moeller from Ogilvy, directs Ogilvy Public Relations Global Public Affairs Practice, named the 2012 Public Affairs Agency of the Year by the Holmes Report. In this role, Jamie oversees a practice of more than 150 professionals operating in 30 markets around the world, assisting clients with brand reputation, policy communications, and corporate positioning initiatives. Jamie oversees Ogilvy's integrated public affairs offering with its wholly owned lobbying affiliate, Ogilvy Government Relations, one of the premier government relations consultancies in Washington. Following Jamie, Kathy Baird Westfall is a Senior Vice President at Ogilvy, Washington, where she leads the digital strategy team. As a senior strategist, Kathy oversees large integrated programs that incorporate digital and social channels across the disciplines of reputation management, PR, marketing, and advertising. She's worked in the digital and integrated marketing space in both the agency and client environment for over 17 years, and her assignments have included corporate, association, government, nonprofit, and academic programs. And finally, last but not least, my colleague and partner Ron Jacobs, to my immediate right here. Ron serves as co-chair of Venable's political law group and as hiring partner in the firm's D.C. office. He advises clients on all aspects of state and federal political law, including campaign finance, lobbying disclosure, gift and ethics rules, and the tax implications of political activities. He also assists clients with crisis response to government investigations and enforcement actions, congressional investigations, class action lawsuits, and other high-profile problems that involve potentially damaging legal and public relations matters. Ron has also been an integral part of our nonprofit practice over the many years that we've worked together, helps to lead many high-profile efforts in our nonprofit group. And the reason he's up here today, you might remember him from last month where he spoke with Larry Norton on a variety of political law issues. But he's also been a key player in Venable's handling of a wide array of governmental investigations. We've handled dozens and dozens and dozens of federal and state governmental investigations over the years for our nonprofit clients, including quite a number right now. Ron is a key member of the team, helps to quarterback a lot of those investigative efforts, and you're going to learn a lot from Ron today. So with that, I'm going to turn it over to Jamie to get us started. Jamie?
Thanks, Jeff, and thanks to Venable for putting this together and hosting it. I think this is an incredibly important topic and an extremely timely topic. You'll see we've entitled this Protecting Brands in Turbulent Times, and indeed, I think these are as turbulent as I've seen in the 20 years that I've worked with organizations managing crises, managing issues, managing government investigations. The scrutiny on organizations, whether they're companies, whether they're NGOs, whether they're nonprofits, associations, has never been greater. That's from the Hill, it's from media, it's increasingly from social media, and Kathy's going to talk at length about the role social media plays today, but it's extensive, and in some ways it's pretty scary. And it's a pretty scary time to be an organization that's operating in the public sphere and sometimes in the public trust, but to have that kind of scrutiny. And also, frankly, to have all kinds of different interests, some of which may be aligned with yours, some of which might not be. And that's a pretty scary place to be. So what we want to do today is talk through how to minimize the scary part, how to actually mitigate, identify risks, mitigate them, manage them, and then hopefully turn these into opportunities, turn issues that occur, investigations, crises, ultimately into opportunities to strengthen your organization, strengthen your organization's resilience, and in some cases strengthen your organization's ability to operate. So a starting point, in our world, issues and crises often get mixed up and frankly are sort of lumped together. I thought it would be useful to start with a quick definition. Crisis is an event that happens, it's something that happens, and we'll talk about why crises occur, but it changes your day-to-day life very, very quickly, and hopefully only for a few days or a few weeks, and sometimes years, and sometimes, frankly, they pose existential threats to organizations of all varieties. It's essentially, we always talk about it's something that goes bump in the night. And how difficult that is depends on how big that bump is and how quickly and how well you respond to that bump and manage it. Issues, on the other hand, are potential problems that, if managed effectively, don't become crises, but they are ongoing. So as an example, a crisis would be when there is an investigation into a product, a company's product or an industry's product. That begins a crisis, and that begins crisis response protocol. An issue would be, there's an advocacy group that has an ongoing campaign looking at the product. That's an ongoing issue that has to be managed. If it's not managed effectively, it becomes a crisis resulting in potentially significant damage, but also then generating crisis response protocols. So the 7 characteristics of a crisis. Again, 1, a sudden change in circumstance. Something happens either in your control, oftentimes usually outside your control, that changes things dramatically. The next step is you never have enough information when something happens, and information is key, but you never have enough of it when it happens. I was advising a client just last week on an incident that took place in India. We were on the phone all night with their colleagues in India, in Mumbai, trying to piece together what happened. And getting that information is difficult, but then the information starts to come in, and then you begin to see that there's actually usually, not always, but usually more to the event and more to the crises than you initially thought. And so that escalation, you then begin to, unfortunately, feel a bit of a loss of control, like things are coming at you from all directions, information is coming in, things are getting worse than you expected, and worse than you probably told either senior management or your crisis team. And then you have the scrutiny, both from inside and outside. You have scrutiny from, if you're an association, from your member companies or your members, an organization sometimes from your funders, but outside scrutiny from the social media realm, which is unrelenting and 24/7, from traditional media, if it rises to that level, which has to be managed and has to be handled, which is difficult, especially in a time when you are still gathering information. When all of that happens, too frequently, organizations go into a siege mentality or really go into the bunker. And the client we were dealing with last week on the India situation, their immediate reaction was, we don't want to deal with this. And the reality today is you have to deal with it. Because once it's out there, once it happens, it will become known. And so a siege mentality will not serve you well. And then finally, the 7th step would be panic. And so our objective today is to help you avoid 6 and 7. Stay out of the siege mentality and don't panic, because there are ways to work through even the most difficult crises, and I think all of us on this panel have dealt with some pretty difficult situations, in a couple cases what we would call a black swan event, which you really didn't anticipate and really couldn't prepare for, but there are ways and there are protocols to manage through them. So how do they begin? And it's actually interesting. We've looked at the crises that we've been involved in, as well as some other high-profile crises, over the last 5 years, just over 5 years. And we've been able to boil it down to sort of 15 categories, and you see them here on the screen. What's fascinating about this slide and about this, again, granted, relatively informal research we did, but you'll see that of the 15 crisis categories, only 3 of them have external triggers. So in other words, of the 15, 12 of them happen within your organization, which means a couple things. One, they can probably be controlled, but things do happen. Things do go bump in the night. The nature of organizations today, the nature of human nature means that things do happen. But most importantly, it means that most of those can be anticipated. You can begin to work, you can begin to plan for them. You can't anticipate the exact nature, but if you look at these 12 categories, and again, a lot of this is from the corporate world, also from the nonprofit world, you begin to see that there are ways you can look within your organization and begin to plan and begin to look at, are there vulnerabilities? Are there areas we should be paying more attention to that perhaps we're not right now? Are there places that we can begin to put in place protocols and plans that will help us mitigate when something happens? So that's where they begin, and then how do we manage it when it happens? It starts with planning. And I will tell you, and my colleagues who are here and clients who have worked with me will tell you that I am adamant about planning. That if you don't start your planning and you don't start your crisis response until a crisis occurs, that's when you have a real problem. That's when that bump in the night becomes an explosion and becomes a big problem. The planning up front and the investment it takes in time, in resources, in staff hours is worth every minute to get it right and to plan up front. So we talk about identifying vulnerabilities. Again, that checklist of 12 areas, are there places there we need to be looking? And frankly, I think you look at all 12. Nobody ever anticipates something going wrong. Nobody ever anticipates someone in your company or your organization doing something wrong. But you've got to begin to look at, if that happens, where are we vulnerable? Looking at identifying who are the stakeholders we need to reach. Who do we need to talk to if a crisis occurs? Again, my example from last week, we couldn't get a hold of the company's CEO. He was off-site. We couldn't find him. Nobody could find him. We went on and on and on, and that was a problem. Not having the CEO engaged in this as we were getting media calls in and out was a problem. And so identifying who do you have to get and how do you reach them. Again, having a crisis team established at the outset. And I think what's incredibly important for a crisis team, it's not just the communications people, it's not just the lawyers, it's not just the government relations folks, it's all of them. They have to work together on a crisis team, be closely coordinated, because the communications people can't do anything that's at odds with what the lawyers need done or can't have done. Neither one can do anything that's at odds with what the government relations people are trying to manage, whether it's on the Hill or in a state capitol or in an agency. And so critically important that those three areas in any organization work together on a crisis team and are represented there by people who can actually make decisions in real time, because today we no longer have the luxury of a lot of time to manage anything, frankly. Third-party resources, knowing up front, who do I need to bring in? Who's the law firm that I need to bring in? Existing law firm, someone else with a specialty, potentially a list of those PR agencies who do this kind of work, a list of those government relations firms. And knowing, and again, part of your vulnerability is what resources do I have, more importantly, what resources don't I have that I need to go find in time of crisis? Don't make those calls and make that list while you're getting inquiries from the Hill or while you're getting inquiries from the media.
And Jamie, if I can interrupt you for a second, this is Jeff. Ron's going to talk about this more when he gets up there. But one thing that we have found very, very important, and it happens early on in this planning stage, is the attorney-client privilege and the attorney work product doctrine. These are important privileges that can help to maintain and protect the confidentiality of the information, the communications, the documents that are being developed, that are being unearthed. And it's critically important in these situations sometimes. Doesn't mean that you're necessarily trying to hide information or documents or keep it from investigators or the media or the public. But sometimes there may be, certainly there's going to be privileged discussions with your attorneys, strategy, figuring out what are the worst case scenarios. You are not going to want those kind of informations and discussions out there publicly, subject to subpoena, subject to disclosure. There also may be, you may do your own internal investigation often as part of these crises, and what you come up with you want to be able to protect under the attorney-client privilege. Whenever an attorney is working directly with a client, say the officers, directors, employees of a client, that's all protected by the communications that regard legal advice in that regard are all protected by the attorney-client privilege. But when you have third parties involved, PR firms, forensic accountants, CPA firms, media consultants, others who you frequently bring in and are part of the team to deal with that crisis, the communications with them, and as you mentioned before, that interaction between the communications and the PR aspects and the legal aspects and the policy or governmental aspects are all intertwined. We're dealing with a couple right now. They are impossible to separate. Every communication seems to have legal implications, and every legal communication seems to have PR implications. So there has to be close coordination. So one thing you can do up front that we do all the time, we're doing actually this week for another client, is having us as the outside law firm retain directly the individual consultants, the PR firms, the forensic accountants, the other strategy and media consultants that are being brought in, so that we are retaining them on behalf of our client. It's essentially a legal fiction that enables the communications between us and the client and the outside firms to be protected by the attorney-client privilege. Obviously, it's important that you don't share those communications with others who are outside that circle. But if you do it that way and you have a proper paper trail and the attorneys are properly involved and kept informed and are providing legal advice in this regard, then all of those communications can be can be kept confidential under the attorney-client privilege. It's very important, but you have to remember to do that right up front, not 6 weeks into it.
I think that's a great point. It is almost always, and that's always our recommendation to clients, is have the lawyers sign the letter of agreement with us. And in some cases, we send all the communications through the lawyers to the client so it's all protected. We worked with a client a year ago on a very high-profile series of investigations. They were being investigated by 3 different congressional committees, as well as by the Department of Commerce. And those were just the federal investigations. And they were extremely high-profile, and in some cases, in one case, one of the allegations was incredibly explosive. And we were hired by the outside firm. Everything went through them. It allowed us to actually see documents we couldn't have seen otherwise. It also then allowed us to handle the communications that we never, frankly, could have done had it just been a one-to-one relationship without that privilege, because the documents were so sensitive and confidential, and in some cases competitively sensitive. So it's a great point. It's very, very important to keep that in mind and to really do that. And again, have that protocol set up in advance. The second stage of the crisis management is then preparation. So you've done all of the planning, you've done the vulnerabilities assessment, but then you actually have to drill. It's like anything else. You have to practice to be good at it. And again, you don't want to be doing it the first time when something goes bump in the night. And so it starts with, yes, can we get a microphone?
Thank you for allowing the question in between. Steve and I, we were concerned that you couldn't get a hold of your CEO in India. I mean, was it deliberate on his part that he didn't want to be taped as you were trying to? Now with all the NSA surveillance and all that, I mean, nobody wants on record.
Yeah, the question for those on the phone was, he was concerned about my example where we couldn't get a hold of the CEO last week. When I spoke to him, we were able to get a hold of him. When I spoke, he was at actually a conference, an internal meeting in Sri Lanka. So again, you can reach people most places. Sri Lanka, you can reach people, but not every minute. But when I actually spoke to him on Saturday, I did ask him that question. Did you just not want to deal with this? He assured us that yes, indeed he did, and he has become quite active. But part of managing the crisis up front is knowing how to reach people. And if you don't know how to reach the CEO, you have to have somebody, is it his assistant, is it his executive director, whoever it might be, who can reach that person. Because times of crisis, they move too quickly. So in preparation, the preparation phase, again, it's drilling. And we recommend a series of tabletop exercises where you really sit around a conference table with the key players, the crisis team, and you present a scenario and say, this is what's happened. One of those 12 scenarios we talked about, but very specifically. This is what happened. We have an employee who's serious allegations against the employee for this, this, and this. How do we then handle it? And then you walk through that tabletop exercise. Having done that on 4 or 5 different scenarios, then we actually do and recommend live exercises. And to do it right, frankly, it has to be a surprise, because a crisis is a surprise by its very nature. You don't know it's coming. And so the call then comes into the organization, and it's the Washington Post, it's Politico, whoever it might be on the phone, and they start asking questions, and then we then see how the crisis protocol goes into effect. Does it work? And then, of course, the key part to both of these is afterwards debriefing and doing a very serious deep dive in terms of what worked, what didn't, where are our gaps, what do we need to fix. But again, having that done before it's real, before the real Politico reporter calls you, or before 60 Minutes calls you, that's a good thing. It will make your life much easier. It will also put you, your membership, your funders, your employees, executive management, all relatively at ease that if something happens, and it almost certainly will in this day and age, that you're prepared for it, you're ready to manage it. Then when the crisis hits, when it does go bump in the night, it is about managing and mitigation. So it's how do we engage with the media, because it's all reactive. The media will be all over you. How do you engage with Capitol Hill, with lawmakers, with agencies, whoever it might be. But again, making sure those relationships and those channels of communications are established before it happens. Critically, utilizing social media tools these days. It's absolutely essential, and as I say, Kathy will talk much more about that, but very, very important that you're managing that channel. And then again, direct stakeholder communications. How do we engage funders? How do we engage the board? How do we engage members? How do we engage folks on the Hill that we need to talk to? But making sure you have those channels established at the outset. And then finally, done right, you see the outcomes on the screen, and I can tell you from experience, done right, we actually do get to this in many cases. Less bureaucracy, much better response time. you can actually shape the story as opposed to, frankly, being a victim. Because if you come back to those 7 steps, when you feel the loss of control, you feel like a victim. And especially in the world of nonprofits, some of you are sitting there going, you know, we're doing good things. Why are people coming after us? That's a natural reaction. So we can't sit back and be the victim. We have to help shape those stories and shape that response. And also, it protects the brand, and it helps manage the crisis and keep it to that specific issue and not become an existential threat to the organization.
Jamie, if I can interrupt for a second. I just want to make sure everyone understands kind of the full array of crises that we're talking about when we use that term, because the crisis sometimes involves the organization itself. It's an instance of fraud or embezzlement, significant fraud or embezzlement that's uncovered. That was a focus of our January program here in this room with Joe Stevens from the Washington Post, where we talked about the series of investigative reports that the Washington Post did about all this previously unreported fraud and embezzlement in nonprofits. And trust me, those organizations that were the subject of those articles, particularly the ones where it had not been publicly disclosed in any material way, found themselves in the middle of a big crisis. Sometimes it's allegation about mismanagement, about dysfunctional board governance, about any sorts of issues, violations of rules governing tax-exempt status. We've seen all sorts of things in that regard, misuse of government, federal funds or whatnot. But sometimes it doesn't involve the organization itself. Sometimes it involves the industry. Well, I shouldn't mention names, but we've done clients for work for a number of organizations in various industries where that industry becomes the subject of a crisis, and therefore the industry association is where the media and members of Congress and other policymakers are going to ask questions, to want comment, to know what the organization is going to do. We've seen that a lot in recent months in various trade associations in various energy sectors like nuclear and propane and others, and coal. And then sometimes it involves just a major member company or a major donor to the organization that finds themselves, he, she, it, an entity, in some kind of legal trouble, and then the nonprofit gets questioned or scrutinized for why was it taking their money or working with them or participating or facilitating whatever conduct may be at issue. So these things can come about in a wide variety of ways, and I just wanted to stress it's not simply about some wrongdoing on the part of the nonprofit organization. That can be part of it, but that's only a small part.
It's actually a really important point, and I do think and we work with clients in every one of those scenarios. I think, though, for nonprofits, management of a crisis in some ways can be more difficult than for corporations, in some ways. And in some ways it's even more important, because very rarely does the corporation cease to exist after a crisis occurs. Very rarely does their brand it happens occasionally, but rarely does the brand become so tarnished that they have a difficult time recovering. I think for nonprofits, many nonprofits, reputation is so critical to your mission and to your ability to provide your mission that anything that tarnishes that reputation, whether again it's something that happened inside or something that because of the industry you represent or people you're associated with, becomes really, really, really potentially damaging and very difficult to recover from, because also most nonprofits don't have the kinds of resources that corporations do to begin to rebuild that trust and their image, frankly. Could we get a microphone? Here, in the middle.
Another quick question on the tarnished image. I think there may be a point at which the corporation may want to dump its own business. Now, a question, do you think General Motors has reached that point?
I will tell you, I've worked with companies where they've had products that have come under attack. And in 2 cases, the ultimate answer for all the right reasons was to stop making the product. And they did that. And they took the right steps and stopped making the product. They've got out of the business. That's not an easy, first of all, it's not an easy decision to make. Secondly, it's not a quick decision. Even if you make the decision quickly, it takes years to do that. So it doesn't necessarily mitigate the immediate crisis, but it does demonstrate long-term that you're a responsible corporate citizen. I think on General Motors, and we don't represent General Motors, so I think they're struggling with handling it in a very responsible way, but getting as much information out as they can. And that's a huge challenge in any crisis, because you want to communicate the information you have, but again, coming back to the 7 principles, you rarely have all of the information you or key audiences need. You rarely have that at the outset. And so when they say we're doing an investigation, to my way of thinking, it's absolutely the right thing to do. But they have to keep communicating. The key thing is communicate what you know, communicate what you don't know, communicate what you're doing to find out what you don't know, and give some sense of when you'll be able to share that information. So I think they're walking that balance, but it's very difficult, and it's also happened at a time of a pretty significant, very significant leadership change in the organization. So I think that they're walking a fine line. So very quickly, we talked about preparation. In terms of action steps, and I think Kathy will touch on this, it used to be, back in the good old days of 5 years ago or 7 years ago, that I always told clients the first 24 hours are the most important time period in a crisis. You got to be up and running in 24 hours. You have to respond within 24 hours. You got to be on the phone with the media in 24 hours. And these days, it's really closer to the first 24 minutes. Things happen so quickly. And again, that's part of what's scary, right? You get the call. You don't have 24 hours to sort of think it through, noodle on it, vet it, call the CEO and talk about it. It requires preparation to respond immediately. And again, you're not going to have all the answers immediately, and you have to be honest about that. And generally, organizations get credit for being honest about that. But it is about responding very, very quickly. So you'll see our action steps, first 3 hours, it really is find out as much as you can. What actually happened? Because in a time of crisis, there tends to be so much fog of information. And also, there's a lot of times people actually either don't have the information or don't really want to share the information. So you have to validate. You've got to get the crisis team alerted, up and running on the telephone, and make sure that we had worked for a very large consumer goods company that had an isolated incident with it really was an isolated incident with one of their products. But what was impressive, it was the Friday before Memorial Day, ironically enough, a couple of years ago, at 4 o'clock in the afternoon when the call came. And they put the crisis team together, and they had everybody on the phone by 5 o'clock. And this Friday before Memorial Day at 5 o'clock, and this included the general counsel, the head of corporate communications, their head lobbyist, their head toxicologist. Were all on the phone. They were able to do that because they had put that team together. So I think that to me was sort of the gold standard. I've rarely seen it in that time period come together so quickly, and it worked. We were able to mitigate that. The news stopped very, very quickly. Within the first 6 hours, and even less, I think, you begin to implement the plan. You've now done the tabletop exercises. You've drilled on it. You begin to implement what the crisis team has agreed to do. But you also have to prioritize who's most important to reach out to and give those assignments. Who on the Hill do we have to talk to? Which reporters are most important? What about our employees? What about management? What about people in the regions if you have operations outside the United States as well? Making those decisions very, very quickly. And then within the first 24 hours, then you really are up and running. You're in the news cycle. You're working with your stakeholders. You're talking to your stakeholders. You're giving continual updates. Depending on the nature of the crisis, you might be holding conference calls with reporters. You might be holding press conferences. We've been in situations like where there is such a demand for comment that we have to put the spokesperson out there every 4 to 6 hours, even to say we don't have much of an update. And we've all watched television when that happens, and sometimes you have to do that. And then again, ongoing, you keep the crisis team together long after the crisis seems to have abated. You get to a point where the news media is not calling, people aren't screaming about it, it looks like we've weathered the storm. Keep the crisis team talking, even just once a day. Keep them engaged, make sure they know what they're doing. Again, we talk here about war rooms. We do have situations that are so intense you go into the war room on an ongoing basis. That's closer to a black swan event, but it does happen. In congressional investigation I talked about before, for 6 months we had a war room set up and a dedicated team, and that was what we did. And then you begin to analyze the impact. What worked? What didn't work? What's the long-term impact? What do we have to repair in terms of our reputation, in terms of our relationships that may have been frayed by this situation? And then again, you see the outcomes. Most importantly, it's about preserving your reputation and making sure your reputation comes through a difficult time unscathed. And ideally, you come through it with something happened, but they actually stepped up to the plate, they did the right thing, they managed through it. And so I will leave you with this. the value of planning, and this is more in the corporate world, but I think it translates pretty well to the world that you all operate in. According to a relatively recent study, this is 2 years ago, by the insurance firm Marsh, every dollar spent in crisis planning is worth $7 in losses averted. So if somebody gave me the option of investing $1 to make 7, I'd probably take that. So I think, again, leave you with the thought, planning is the most important thing. If you plan, you can manage almost anything. So with that, I'll turn it over to Kathy, unless there are other questions.
Thank you, Jamie. That was a great lead up into some of the things that I'm going to talk about with social media. And again, I'll take questions as we go, so feel free to raise your hand and chime in. But I think it's really an understatement. It's probably pretty cliche to say that social media has really transformed the way that we communicate today. But when it comes to a crisis, like the interesting paradox of that is social media is both a threat to us and sometimes how a crisis breaks, but it really is kind of a lifesaver in terms of how we're going to rebuild ourselves. So it's a really critical channel to think about. And in all the planning Jamie talked about, planning for some of the things in social media can be really complex in terms of who posts when and who approves what content and how do you really run a rapid response team in getting your message out there. With social media and a crisis, there are a few things that are really imperative. They're really kind of critical in terms of how they affect a situation. It's real time, so crisis can break in a moment, and there's an expectation that we will respond in real time and even in a shorter amount of time than 24 minutes. The second is it's 365 days a year, so social media doesn't close for business hours. They're open overnight, and I've been in situations both on the client side and on the agency side where we've awoke to terrible news, or you've been woken up in the middle of the night on behalf of this, and it also has a wide reach. It has the power and propensity to reach millions of people in rapid speed. So I'm going to talk a little bit about some trends, and we'll get into some of the specifics about how you can really utilize these channels, both to prepare for a crisis and also prevent them as well too. I think just an interesting point that I would make, just to echo on the planning aspect, there's a study that's been done where in 2001 there was one crisis that really kind of made public headlines, and I put social media in quotes because at this time in 2001 all we had were forums, and you might remember the Enron days. I grew up in my career during that because the next crisis that happened was WorldCom, where I was employed, and we were quickly hit with making decisions in real time and really thinking about how forums, which seems funny today because we have Facebook and Twitter, but how forums were really affecting the reputation of the organization. And there was nowhere to look for best practices at that time, and there was no planning that had been done in advance of this. And so among these companies, there were 10 that broke in 2011, and experts have recently made this determination that 76% of these could have been prevented or mitigated with proper planning. So I can explain some of the ways we can do this in the social media landscape. I think it's also important to note that it's not really about the platforms themselves, but it's the trends that are happening kind of throughout the social space and in the industry and corporate America, also in nonprofits, that are really affecting the ability of social to influence crisis communications for good and for bad. The first is the mouse that roared, which is kind of a funny phrase. I don't know if any of you saw a New Yorker cartoon. It was back in the early days of the internet, maybe, I don't know, in the 1990s, and it said, on the internet, nobody knows you're a dog. Well, that's very different today. On the internet, everybody knows you're a dog if you're out there. And I think what's changed is that back in the early stages of the internet and of social media, if there was someone commenting on an issue, you tended to think this was a poor delusional blogger sitting in their basement typing on a computer. But the reality of that is that with the combination and the reach of social media and the internet, teams of people have been able to come together and form, even if they're not the most intelligent souls in the universe, they're able to form the ability to solve puzzles to things. And there are a lot of stories kind of about how teams have come together and broken different situations where there was plagiarism in journalism, for one thing. Calling to mind, different product issues that are happening around the country. With the power of that reach, these things are often breaking. And so, the mouse is no longer, a harmless little creature. The mouse can sometimes roar back at us. I am a camera. I think probably our greatest invention today, and also our scariest, is the smartphone. Number one, it's the picture quality that a smartphone is now capable of taking. The second is your ability to disseminate that information immediately to millions of people, and being able for those people to share it with their millions of people across the network. Also, the time lapse between reporting and sort of news breaking the cycle is now down to 0. So when there are issues and crises that are breaking or events that are happening, I mean, the definition of reporter is even changing. It becomes your everyday average citizen who's able to capture a moment with a smartphone on a camera and be able to post that widely across the internet. The other thing I think that's important about photographs is that they arouse emotions and outrage in a pretty rapid way. So it's not just a story, it's not just text, it's not just a headline. It's a picture of you witnessing something that you're then able to share to the masses, and really it can fuel crisis, it can fuel activity throughout social media channels. Second is convening the masses. If enough people in opposition can get together, they can do some pretty extraordinary things. This can be used for good. For instance, in Canada, there were about 400,000 people who signed on to a petition to get a cancer treatment, the opportunity to participate in a clinical trial to save his life. So that's for good. But you can imagine on the other side, it also involves things like product boycotts, different organizational protests, and the spontaneity of social media and that ability to really convene the masses can quickly spiral out of control, both for good and for bad. Trend 4, which I think is really interesting, is really a trend that's happening in the social space regardless, and that's data. I think more than ever before, public transparency is pretty important in probably all of our industries. And the ability to gather data through technology and through publicly available information is something that we've been able to use as a great benefit sort of across nonprofit and corporate worlds in terms of developing campaigns that really resonate with audiences. At the same time, any opposition we might have also has access to this public data. And so when you think about things like emissions reports from manufacturing organizations combined with zip code data, that can form a pretty powerful tool for activism. And so we've seen a lot of this sort of use of data, publicly available information being used to carve out scenarios that are of great benefit to some organizations that have very strong opposition to certain issues. And so as I mentioned in the beginning, I think it's interesting to note that the channel which, in sort of corporate responses, you have to really pay attention to, and there's a little bit of fear, I would say, on the corporate side sometimes of really engaging in the social space. It really becomes our opportunity to solve that problem and to rebuild our reputation and really to come out from under. Before digital and social media, a crisis required us to really defend our cause or our organization or our issue with advertising or maybe a press conference or some kind of traditional media, and we would just sit there and we'd cross our fingers and we'd wait and we'd hope that they covered us in the way that we wanted to be perceived. But today we have social media, which is where a lot of that sort of activism and perhaps outrage is happening. We have to jump into that water and learn how to engage in a really appropriate way in order to be able to rebuild that trust. So as I mentioned earlier, social media allows us to connect in real time. It allows us to really listen to the concerns that are happening in real time, respond to those concerns, and it's really a channel by which we can disseminate information very quickly. So I'll go through right now 5 benefits that we can look at, and then we can talk about some planning as well too. So the first is crowdsourced information. Our ability to manage any kind of reputational fallout correlates with how quickly we're able to make the right operational decisions. And this is oftentimes a situation, perhaps in the energy industry, a particular power plant, et cetera, where a crisis happens. Let's say there's an explosion somewhere and they need to get information very quickly out to people that are affected, to the media that's concerned, et cetera. So anytime we can get information better and faster, it will benefit our organizations. One example was during Superstorm Sandy. Con Edison of New York was using Twitter to really tap into communities that were affected and needed support, and they were able to then send response teams out to those communities based on what they learned from crowdsourced conversation. So I think that's a positive outcome from something that was a pretty disastrous scenario. The second is hyper-communications, and so Jamie mentioned 24 minutes, and I would say it's kind of second by second or hour by hour. If you're with an organization or you're working on behalf of an organization where there is a crisis that's happened and there is safety concerns, there's kind of immediate need to get in touch with your audiences, social media really allows us to sort of get the public updates out on an hour-by-hour basis. And so it's the one channel by which you can communicate to on the half-hour, on the 15-minute increment in terms of notifying audiences what's going on, where, who's affected, and how you're addressing that situation. I think that's kind of interesting, as Jamie mentioned. A lot of times you find yourself in a situation where you don't have the answers and you don't know the answers. And I would argue that actually in social media, it's okay to say that. It's okay to say and be transparent. We don't know, but we're working on it. We'll provide updates in a timely way. So that kind of hyper-communications is to be expected, and it's very accepted and welcomed in the social space. Compelling narratives. I think the power of narratives in storytelling is particularly effective when you are trying to rebuild after a crisis. I think in the immediate term what's required is information, facts, updates in a timely manner. I think when you're rebuilding your reputation, you want to be able to show the human side of how you're addressing the situation. And so videos of different scenarios where you're sort of rectifying things or addressing situations, it puts a human face on it, and I think these are great tools that you can share through social channels, but they're also equally as effective through traditional media as well. One-to-many and one-to-one. There's this term called the social media terrorist, and I think that's sort of that individual that you're afraid is going to just really explode things in your social channels, and they do exist, and we have had to deal with them. There's always sort of questions on how you address this individual. Do you address them in person? Do you ignore their comments? Do you delete their comments? Our advice on this is to really go one-to-one, and a lot of times when these matters are handled, or these individuals are handled very early with one-to-one dialogue, whether it's through direct messaging, which is the behind-the-scenes feature on Twitter, or messaging through Facebook, we're able to diffuse situations, and it's been fairly surprising in terms of being able to diffuse those on a quick basis when you deal with it immediately. Another benefit to social media is that you're able to track sentiment in real time, which I've seen this area evolve quite a bit in my journey in working on the social side. These are things like the intensity and the duration of the social media conversation. Through a variety of tools, there's some pretty robust technologies and platforms that are out there. Radian 6 is one, Visible is another, Crimson Hexagon is another. These are monitoring tools. And through these we can evaluate how frequent our issue is mentioned in social media, how frequent our brand name is mentioned, the tone by which people are talking about us. Is it positive or negative? Is it neutral? We can look at things like the search intensity and things that people are typing into Google to find information about us. So keeping an eye on this. The other thing is the social platforms all have great analytical tools on the back end. So Facebook has Facebook Insights, YouTube has that, Twitter has as well. So you can get an understanding of what's happening, and with all of these tools you're able to really kind of stay on top of things, both in advance of a crisis as well as during a crisis as it's happening.
Since you're talking about social media and tracking sentiments in real time, I'm just wondering if you followed the case of the Malaysian Airlines. Did they do something wrong by letting the relatives of the people who were traveling to come to Malaysia and stay in a hotel, and rather than using the social media? Because nowadays with the social media you don't have to incur all those expenses. Do you think they did? I don't know whether that's your job or not. Did they do it the right way?
I think that's a good question. I think social media doesn't replace in-person, face-to-face communications. And I think in that matter that affected many human lives. I think that requires a great degree of face-to-face. Social should never replace that. Social media is a tool that you use to supplement your activities, but I don't believe it's a tool that should replace any kind of face-to-face issues that you're dealing with. And again, we are talking about using social media as a tool, but I'm a strong and firm believer that it's only as effective if you are really doing the things you need to do as an organization in all of your offline channels as well as your online. Did that answer your question?
Yeah, I was just curious if they could have really talked about this once a month.
That's a bigger question, yeah.
Whatever you said, 14 minutes. They didn't change. They keep your money.
Sorry? Okay, sorry. Moving on? Good? Okay. So in terms of a social media crisis framework, there are 4 things. A lot of these do reflect on some of the things that Jamie talked about earlier. The first is readiness. So there's a lot of planning and preparation that we recommend doing beforehand. And setting your team. I think a lot of times I've seen some trip-ups happen when you haven't had the right team identified. Who's making what decision? We call this a decision tree. So you really kind of think about all the parties that are involved from a legal standpoint, from an authorship standpoint, from an approver standpoint, from who has actually the keys to post content live. And it's really making sure that these protocols and processes are set in place at the very beginning. The second is radar. So, I mentioned the listening aspect of using some monitoring tools to really get an understanding. I think with a crisis, when a crisis breaks, you don't want to be caught without an understanding of what communities are relevant to you in the social space, who the influences are, who can either carry your message in a positive way or who might be the detractors who are going to pull you down. I think you'll want to know who those individuals are beforehand, and it would be even better to have developed some sort of relationship with them in advance of that. Response is the third thing, so that's tone. I think in social media, what oftentimes doesn't work is corporate speak or sort of a tone that's distant. You're going to want to remember that you're communicating on a person-to-person level, and in many crises, in every crisis, I think there is an expectation of being human in terms of how you're addressing that. And then last but not least is recovery. I think when you're recovering from a crisis, a lot of times you kind of wipe your face and you think it's over now and you kind of go back to business as normal. But in the social channels, there's going to be a disconnect if you've been treating them in a special way, in a very careful way, in a very proactive, frequent communications way, and you retire those and walk away. I think what's expected is to keep that ongoing relationship and really use that as you continue to rebuild trust along the way. Are there any questions?
Great, thank you. So now we'll switch gears a little bit from the communication side to more of the legal side and some of the issues that go along with the crisis, or in particular as we're thinking about the government investigation of a nonprofit or a member of a nonprofit that we have to take care of. And there are some common issues, I think, that go along with governmental investigations of nonprofits and other organizations to think about. And the first, at the very top of the list, is what I deem as document production. I'm going to come back to this in a few different places here. And that is almost no matter what kind of investigation you have, whether it's a state attorney general, whether it's the IRS, whether it's Congress, a different agency, the FBI, there is going to be a request for your documents. And the strategies that you have in place to produce those documents, to review those documents, to claim privilege on those documents are just incredibly important, because at the end of the day, how you handle your documents will depend on whether the chairman of the committee has an email that he can read from where you say some very bad things in an email and that makes the evening news, or that gets tweeted out immediately. And so that's one of the first things to think about in how you handle a government investigation. Another piece that we talked a little bit about before that Jamie and Jeff talked about is the internal investigation. How do you get to the bottom of the issue yourself while you've got a number of different people on the outside looking in? How do you hire the experts to do that investigation? How do you make sure that you've got the right report coming into play? And with a nonprofit in particular, that can be a big issue, because who gets that investigation? Well, a lot of times it's going to be the board. Well, with a nonprofit, unlike a corporation, the board is often quite large. And as I've had a number of clients say, their boards leak like sieves. So no matter how many times you have the lawyer hire the investigators, that you set up all those privilege protections that Jeff talked about, sometimes when the report is done and you have to distribute it to 42 board members, it's not going to stay confidential. And so you have to think about how whether you're even going to do that investigation. If you are, who's going to get it? Maybe a summary is what you give to the board and do an in-person briefing. I had one client where they really did not trust their board, so it was almost like taking a standardized test where each report had a number, copy 1 of 42. We handed it out. They gave us the copy back after they reviewed it, did the briefing on the phone. Another situation where, rather than sort of the call-in conference line like we use today, they had a service where they called out to make sure that they got just the board members and they knew who exactly was on the line when discussing these things. So all kinds of very important things to think about when you're reviewing these kind of issues.
Ron, if I can interject there for a minute before we move on. Internal investigations are not only important for the reasons that Ron indicated. When you're hit with a crisis and there are alleged facts that transpired in or around your organization, the management, the legal team, others who are running point on the investigation need to know what happened before they can figure out what to do about it, what to disclose, what not to disclose, what our strategy should be, whether we should fully cooperate, whether we should fight back, whether we should go after third parties. There's all sorts of different potential angles that this can lead to. But also, that internal investigation is so critical. We've conducted, probably in the last 6 months alone, at least 6 or 8 different internal investigations. A crisis hits, we have to do an internal investigation. In every single one of those cases, we've used the results of that internal investigation differently. Sometimes it was to figure out whether there was internal wrongdoing, but with respect to the external stakeholders, sometimes it's the board of directors, but a lot of times it's other external stakeholders. It's organizations that provide funding. It's government agencies. In one case, it's Department of Justice and Securities and Exchange Commission. In all of these different cases, they, of course, want to know what happened. They want to get that information. But sometimes, if you do a good job and a credible job at that internal investigation, you can then take that and shape it and frame it and deliver it to those other parties in a way that can short-circuit a fuller investigation by those external parties on their own. And we've been highly successful in a number of these recent cases in doing that, but it's only because we did a thorough, credible, objective internal investigation and then had the results of that to be able to write up and shape and deliver in an advocacy manner on behalf of our clients. So don't underestimate the role of that. Just because someone is coming in and saying, we want to see this, we want to know what happened, doesn't necessarily mean that you need to or even want to open the floodgates to say, all right, come on in, take a look at everything you have. You may ultimately have to do that, but going in and looking at things yourself first can be a critical first step.
When you're thinking about internal investigations, another thing to think about is who's going to do the investigation, or at least who's going to be sort of the author of the investigation. Generally, it's going to be a team of lawyers who are interviewing witnesses, putting the report together, but who's that person who's ultimately signing off on it? In one case, we had a state regulator, a retired state regulator in the area that the association was being investigated in, brought in to do the report, so that it was someone who had a little bit of a third-party, independent, objective type criteria that could be used. And that's another example, as Jeff was saying, where you deliver that report to the right folks, and it can circumvent or short-circuit some of the longer outside investigations that go on in the area. Another thing to think about are the witness interviews. Who are your witnesses going to be? Low-level employees that are going to be interviewed by perhaps law enforcement, higher-level employees, the CEO that's going to sit before Congress and be grilled. Think that through so that you know how to prep for each of those things, what information is going to be said, avoiding the dreaded false statements kind of charges that often come out during interviews or when witnesses are put under oath. Think about, at the end of the day, if it's Congress that's investigating, is the committee going to issue a report? Is there going to be a hearing? It's going to be one of those things where you get that clip on the news where your CEO, number one, has to raise their hand, and it's awful sort of coverage. But even worse is when the committee members are grilling the CEO, and the CEO has to say, I don't know, I forget, I don't remember, or worse yet, says the wrong thing, gives the wrong answer. all things to think about as you plan through the investigation. A lot of times what happens after a governmental investigation is there's private lawsuits that come on to play on the scene afterward. We have a client right now that we've done a series of congressional investigations over the years, and there's been no less than 4 class actions that were sort of spurred by those. In several of them, they read the committee's reports and decided they could come up with class action allegations. So keep in mind that there's going to be sort of not only the external stakeholders that you care about and you want to satisfy, but also the class action plaintiff lawyers almost become a separate stakeholder that you have to worry about and make sure that the information that's being released isn't going to set you up for failure there. And then a lot of what we're talking about is really in the congressional space, it's just an investigation. It's an oversight hearing. Agencies, it's usually civil liability, but there can also be parallel criminal investigations. You're dealing with perhaps the IRS on a tax-exempt matter, but then you've got the Department of Justice in the background because they're concerned about false statements to the IRS or things like that. So you've got to be very careful along the way, and your response will differ depending on who's investigating.
And sometimes you get one that leads to another that leads to another. I remember we had one started not surprisingly with news reports, major front page national newspaper with news reports that spawned a long series of IRS audits and private litigation, but then spawned congressional investigation and hearing, then spawned Department of Justice Tax Division investigation, and then spawned an even bigger IRS audit. Surprisingly, the organization is still standing well on its 2 feet and surviving well through some careful crisis management and, of course, great legal representation. But don't underestimate the power of which agencies love to jump on board. State attorneys general are notorious for trying to make their way politically by latching on to things that they see in private litigation or in federal actions or in Congress. And so there's often that spillover effect in these situations.
One of the things I think is very similar between what Jamie preached and what I will preach here is to be prepared ahead of time. And there's a few other angles that I'd like to lay out to think about before the crisis hits. But I will start by saying that I think everything Jamie said is spot on in terms of preparation. That's really how you have successful management of a crisis, a government investigation, or anything else, is to have that prior preparation. And so the way I see it, there are sort of 4 boxes to think about. And we'll go through each of these. One is that you evaluate your risks, you establish controls, you develop that crisis plan that Jamie laid out so well. And then the other box, as I said when we first started out, the documents to me are always the thing that comes usually to bite you. So how do you plan to manage for documents? So let's go through each of these, and let's start with that one with the documents, which can, of course, sounds boring, your document retention, what are you going to do? But think about how many times you've seen the emails that caused the case to start in the first place, that provide all the evidence that are used on the big screen in the congressional hearing for the quote. So what I would say is, if you can control your documents to begin with, you're less likely to have those. So think about a document retention policy. It doesn't have to be complicated, and in fact, the more straightforward and less complicated they are, the better. But key to a document retention policy is that you've determined how long you have to keep each document for, and then you get rid of it and you follow that policy. Because at the end of the day, if a government investigator says, hey, we want all documents from 1980 to 2014 on this topic, you can say, well, you know what? We get rid of everything after 90 days, or we get rid of everything after 180 days, except for these categories. So you've immediately lopped off a large chunk of that document request. Now, one of the things you've got to make sure is that you also don't have the backup tapes that are kept somewhere. But if you really are doing the document retention that way, that's a fair answer to say that we don't have them. They're gone. And make sure that when you work with your vendor on the document retention, that they really are getting rid of it, that there aren't servers somewhere off in the mountains buried deep underground where there is a backup. Make sure you're accurate on that. But that's the key piece there, is that you can help reduce the number of documents. And 2, depending on the size of your organization, think about a system that indexes your documents as you go. We had one client, a large trade association, where they were being investigated for lobbying on a particular issue that they were involved in. It was a fairly nasty investigation. There was a broad document requests, but their in-house legal team had set up and been prepared for a very long time for different document requests, primarily in civil litigation, but the system worked. And so when Congress came knocking, we were able to tap into that same system, very effectively produce the documents, or find the documents, review the documents, produce only what was necessary in a way that let us do was respond quickly to Congress, kept Congress happy. Some of the other associations that were being investigated at the same time took longer, drew the negative attention of the committee, were the ones who were called before the committee for hearings, whereas our client was able to kind of skirt by because they got the information to Congress quickly. So it's a very, I think that 1 to 7 example that Jamie gave, this would be certainly worth every dollar spent on the document preparation side of things, and probably a lot more.
And Ron, on the financial side, and of course it's going to save you a lot of time, be able to be more nimble and responsive. But do you want to talk for a minute about how incredibly expensive it is to search those documents? Because we're not just talking about letting someone come in and do a search of your documents. In almost all these situations, you need to have the attorneys go through all these documents first. They need to see what's responsive, what's not. They need to see what documents and information and communications are covered by attorney-client privilege that aren't going to be disclosed because they're protected by attorney-client privilege. That is an unbelievably expensive process. You would be shocked to see how much time and how expensive it is between the legal fees and the third-party vendors that you often have to utilize to help with the electronic discovery. It's a massive, massive cost, and anything you can do on the front end to help mitigate those costs is going to be very helpful.
Absolutely. If we let you walk around in sort of our actual work floors instead of just our nice, pretty conference room, you would see lots of rooms where there are teams of attorneys reviewing documents, and they're, of course, all billing out at an hourly rate, so it's a very expensive proposition. And then there's the risk, the more documents you have, even with electronic coding, there's a risk of missing something, that you accidentally turn documents over. Almost, it seems like weekly, there's a story about documents that should have been retained as privilege that were turned over to the other side, and there's the question, well, how do you claw those back? What's the result once they're out there in the public? Things like that. So the fewer documents you have, the more accurate you can be, the less expense there is to go along with it. On the risk management side, there's a few things to keep in mind. One is who's going to be involved in the risk management process, and what are the risks that you're thinking about? Excuse me. You know, a lot of risk management, you think about things like financial controls, making sure no one's embezzling money from the organization, you know, your liability policies in case someone slips and falls outside your front door. But really drill down on the risk. If you're an organization that's lobbying on behalf of a high-profile industry, think about the risks of doing that. You're going to have to accept those risks because that's what you're in existence to do. But know that that's going to come with congressional scrutiny, that that's going to come potentially with you know, investigations by state regulators, things like that are going to happen. So evaluate the risks, understand that what the cost-benefit trade-offs are and how you're going to do it so that you're ready to make those decisions. Include the board of directors or the executive committee as you need to. Make sure the senior management's involved, and make sure you have a good information flow. One of the more difficult situations I've seen people in is when a somewhat obvious investigation starts, and the board is shocked when they say, well, we've got to hire a PR firm, we've got to hire the law firm, and your bills are going to be, you know, very large. The board is shocked at this. Well, if you had the right processes in place, the right information flow, the board might recognize, or the board would have been informed to say, look, we're lobbying on a very hot-button issue here. If we do this, which you want us to do, know that it's likely that this is going to happen, and here's how much we're going to have to reserve to make sure we can cover our legal fees, our PR fees, everything else that goes in along with those kind of investigations. Some of the things then to think about are what kind of controls do you put in place to mitigate some of those risks? You know, the obvious things with theft, you make sure you have your financial controls in place. You make sure that your regulatory filings are in good order. You know, something as simple as the 990 that you have to fill out every year for your nonprofit, to make sure that the right group of people are looking at that so that you don't say something in one of the narratives that raises a red flag. That the numbers balance like they're supposed to balance. You'd be amazed at the number of 990s that we get into our nonprofit group to look at, where it's simple, you know, numbers don't add up, and these were sort of handed to us the day before they were going to send them in to the IRS, after the board had reviewed it and everything else. Or in a good example where the lobbying numbers on the 990 just don't make any sense compared to other lobbying filings the organizations have made. So make sure you're thinking about all these things. If you have lobbying disclosure filings, make sure that you're putting a good spin on things. You might be lobbying to you know, do things that a lot of people would not like, you know, destroying dogs and cats, but make sure you say it in a good way to try and minimize that risk. When you're developing your public policy positions, again, make sure that you've got the controls in place so that one person can't sort of go rogue, come up with a different policy that's not what the organization is looking for. We've seen a number of situations where it's the misshapen policy or the premature policy gets released that hasn't gone through the full executive committee or the full board to be vetted, and it would have stopped some of the negative problems that occurred by that. And then the final piece is to make sure you've got your public communications controls in place. And this touches, I think, on everything that Jamie said in terms of your crisis management team. But make sure that you know if you've got a whole group of people who are out in the field with communications or with your social media, that you've got the right controls in place to make sure that people can't, again, go rogue on the messaging, which can lead to one of these other situations. And then finally, the plan. And again, I would say this plan fits underneath, next to, beside the plan that Jamie laid out. But in some of these things overlap already with sort of the organizational notifications, who within the organization gets called upon. How do you put the document holds in place? Again, this gets back to when a subpoena comes in, how do you make sure you don't destroy the documents that you're supposed to keep?
Yeah, and as Ron knows well, this is generally the first thing that we always do the second we hear from a client about an investigation, whether it's private litigation, a governmental investigation, anything of the sort. You immediately want to send out what we call a document hold notice. It's basically a notice, a written notice to all relevant staff, and sometimes even officers and directors and others that have access to information and documents that's relevant, to say don't destroy anything on point. If it's a federal investigation, it's a violation of the federal Sarbanes-Oxley Act. That provision does apply to nonprofits to destroy any documents or information in connection with a federal investigation. And similarly, it's going to be the same basic rule for other sorts of governmental investigations or private litigation. And so sending out that hold notice to all relevant staff, sometimes it's all staff, sometimes it's only relevant staff, and sometimes it's other volunteer leaders as well, is a critically important first step that you can't afford to wait to do.
Absolutely. When you're gathering the information, again, think back to one of the first questions that Jeff posed, is the privilege. Make sure that you have the right team of lawyers doing the investigation to keep the information privileged. If you send out other folks within the organization, the CFO, for example, may be involved to figure out a financial irregularity. If there's not an attorney involved, then that investigation is not necessarily privileged. Think about how you're going to deal with the press and how you're going to retain all of your experts. Again, things that dovetail very nicely with Jamie's points. Now, what about when you're in the storm? Again, we come back to the privilege point, I think, that's important. I think one of the things to keep in mind about the privilege, as great as it is when you're dealing with civil litigation, with executive branch investigations, state investigations, it can be very effective. You can protect some of your information. Congress doesn't like the privilege. They take the view that the attorney-client privilege doesn't really apply all that much. I had a case a few years ago where the Energy and Commerce Committee was investigating. We produced a privilege log, which is sort of a list of document X with this date from so-and-so covering this information. We produced the privilege log, and then the committee staff called up and said, you know what? We'd like to see those documents. Can you bring them in? And there was, there's no, never in private litigation, or even if the Department of Justice were investigating, would that ever occur. But given the threat to the client in terms of the bad PR, and because we knew that the documents in that situation actually weren't too bad, and some of them were potentially helpful, we walked them in. We agreed that they would look at the documents. They wouldn't keep copies. They could take notes, but only their own notes. So they looked at the documents, we flipped through, we were done in an hour, and that was that. So that's just something to keep in mind, that's not necessarily going to work with Congress. It's amazing the breadth of how congressional subpoenas can play out.
Ron, we have one question from the webinar that says, when you're conducting your internal investigation, is it always important to use an outside firm, or particularly a law firm, or is this something that we can do ourselves with our own staff? Do you want to speak to that issue for a minute?
I guess part of it is going to depend on the size of your legal office. You've got to make sure you've got the right skill set of lawyers to be able to do it. But that being said, to protect the privilege, the courts are much more likely, I think, to respect the privilege, to observe the privilege if you have the outside lawyers doing the investigation as opposed to the in-house lawyers. There's always the risk with the privilege issues that the other side will argue that it's a business decision that's being made, that the lawyers are involved in a business proposition rather than sort of the legal investigation. So it's just generally, unless you have a very strong, large in-house practice, I would say it's almost always better to have the outside lawyers do the investigation.
Okay, Ron, just to chime in on the communications front, because that investigation is a key tool in communications, and an outside firm has much more credibility, fairly or unfairly, in the media. If you're conducting an outside investigation with a known firm that does this sort of thing, it's seen very credibly, and it demonstrates to the press, to other stakeholders, you're taking it seriously.
And one very recent example that you might want to comment on, Jamie, the New Jersey Governor Chris Christie, wrapped up in that bridge scandal in New Jersey, brought in an outside law firm, a big national law firm, to do an internal investigation. Well, not internal, to do an investigation, obviously designed to give it some real credibility. Seeing the press coverage afterward, there were still questions of how credible really is it, because Christie hired this firm to come in and do it. Do you want to comment on that at all from a PR perspective?
Yeah, from a PR perspective, that it's so wrapped up in politics and obviously presidential politics. And the whole thing was so incredibly political that I think he was damned if he did and damned if he didn't, frankly. But I think the instinct to hire an reputable outside firm that people know was probably the right one. But of course, then automatically, well, the governor hired him. What outcome did he expect? And the other thing is, I think from a credibility standpoint, a communication standpoint, you have to be willing to abide by or to act on the results of the investigation to have any credibility. And he sort of did that. And I think that sort of held him back a bit.
The other thing I think with governmental investigations that's so important is to figure out how you're going to interact with the government. And you might have different strategies with all of the different agencies that are investigating you. And part of that's because of their relative power or authority. As I said with Congress, they have very broad jurisdiction, and they don't recognize the attorney-client privilege. So how you interact with the congressional committee may be much different than how you interact with the Department of Justice or another regulatory body where you can claim privilege on those documents. Where if you're in a situation where it's civil litigation initiated by a governmental body, there are rules of civil procedure that might limit the number of document requests, that limit the number of interrogatories that can come out that you just don't have with other agencies. So think about the negotiating position, but probably above all, one thing that's I think, consistent with all the investigations I've done, even when we've taken a hard line with an agency or tried to press back with a congressional committee, develop good relationships. Make sure you have a team that either has existing relationships or can build that sense of trust with the agencies. It makes a tremendous difference, because even if you're adversarial and it's going to be a push, very hardly fought contest, at the end of the day, you get so much further in the situations that I've seen when you have the trust of the other side and the confidence of the other side that you can actually act in a professional manner. If you've got someone who goes in and just sort of stomps their foot on the table or bangs their shoe on the table, it doesn't get very far. And again, I've seen a lot better outcomes when people work with the committees that are investigating, even if they're usually more successful in narrowing the scope of the requests, providing what the committee really needs. It's often a much better outcome than taking a year to sort of produce documents, backing the 18-wheeler up. The committee is not exactly thrilled when they've got to get their people to go through that many documents. So even though there's more documents, you might think you can hide something. Most of the time they're going to find it. So it's better to try and do the targeted production, but it can only come with a good interaction.
Wait, hold on. While we're waiting for the microphone, I just want to echo Ron's comment and stress how critically important that is. In the dozens and dozens of nonprofit investigations that we've been involved in and that I've been personally involved in, we've always taken great pains, and everyone on our team that works with us kind of has the same approach of building a great rapport and trust with the investigators, whoever the lead investigators are. It doesn't mean you're always going to agree with them. It certainly doesn't mean you're going to roll over. But you need to be professional. You need to be businesslike. You need to not be unreasonable. You need to respect deadlines and be reasonable in requests, push back where appropriate, but willing to concede on things that aren't as critical to your client. Doing that has gotten us so much farther, and usually it ends up helping us to be more successful in negotiating a good end result, because most investigations wind up not with the government agency filing a lawsuit, but with some sort of a settlement, some sort of an agreed upon resolution, agreed to engage in some practices differently going forward, agree to pay a little money, agree to give some restitution to some consumers, agree to remove people from your board, put in new governance practices, whatever the case may be. But you're going to be more likely to negotiate a successful resolution if you developed a good professional rapport with the investigators. So what was your question here?
So you're talking about Congress, but what about if you have an employee who's approached by law enforcement, FBI you mentioned earlier? What do you put in place when you can't really even envision that happening?
It's a good question. I think if employees are approached, one of the things to keep in mind is, again, sort of a procedure in place where if it lets employees know that if they're approached by law enforcement, they should determine whether it's an individual sort of request. Is it something that they've done? Is it related to your organization? They should notify whatever management you just deem appropriate, whether it's the CEO, the general counsel, because number one, you may have an issue with your insurance coverage. Your insurance carrier may provide coverage for this employee under a D&O policy. You may want to provide the lawyer, pay for the lawyer to make the employee happy, keep them on your team, as opposed to now if you determine, say, it really is a rogue employee, they're the ones that are causing the issue, then it may be that you cut that employee loose, fire them, do whatever, let them hire their own lawyer. But you've got to sort of know what the investigation is about so that you can figure out the right approach and strategy there.
And Ron, one more quick comment on your slide here. This is Washington, don't forget, so don't underestimate the power of different government agencies and different bodies of government to be able to influence what's going on in another department. We do this all the time by using our clients' friends on Capitol Hill to try to influence the direction of a governmental investigation. That works better with some types of agencies and some types of investigations than others. For instance, it rarely does anything with IRS audits. In fact, it can really backfire. The IRS hates to be, at least seemingly on the surface, hates to be influenced politically, although we certainly know and we've seen that a lot of IRS audits can be politically inspired. They definitely respond well to pressure on the Hill in starting audits, but they hate to be influenced in the direction of an IRS audit based on political pressures. But using your friends in different governmental, federal, state, or other agencies to influence what another agency or another branch of Congress, a committee of Congress is doing can be a useful tool.
We had a client recently where Congress Chairman Iss's committee wanted a particular piece of information that was actually prepared under a government contract. The federal agency that was the contracting agency told our client not to produce it. So we were really between a rock and a hard place. We were very close to bringing in the third branch of government, the courts, to solve our problem for us. But we, through negotiations, found another option, sort of a last-minute, 11th hour kind of deal. But you can get really stuck in different areas, and why it's so important to develop those relationships and use the agencies as you can. I think we've already covered a lot of the document request materials. When the document request comes in and the subpoena comes in, make sure you immediately issue the litigation hold, figure out where the documents are, determine the scope of privileged materials. Those kind of things are very important to do. And as we talked about a little bit, the real cost is in the electronic documents because there can be so many of them. So make sure that you've got your IT vendors involved in the process. There have been a number of times where we've had clients say, we can get you our documents, then you can do the review, and they're not willing to spend the time, a little bit of extra money with an experienced vendor who does these kind of things. The information comes in, and it's not what we need. It's not what can be produced. We have to go back to square one. We've lost time. We've lost money. We've lost goodwill of the investigators. So it's really important to get the right assets in place immediately to conduct that kind of discovery. And then also, again, no matter what agency you're dealing with, and this is why these relationships are so important, you can always negotiate. You can, at the end of the day, the government has the upper hand in these things, but there are ways to talk to the government to figure out what you're going to produce, to narrow the scope. Say, look, what are you trying to figure out here? Maybe we can give you this subset of documents. Or let's talk about, rather than trying to find out of 200 employees everyone's email that you're looking for, let's figure out the 3 most relevant employees, and we'll go through their email and find the documents for you. How are we going to produce it? Are we going to do paper? Are we going to do electronic? Are we going to do a rolling production instead of just a set date? That usually makes the investigators happier because they can start working on their end. And we can keep working on there, and we get sort of a longer deadline. So those are all things to think about in the document production space.
And don't underestimate the importance, too, of using different people within your law firm or within your organization or other outside consultants in different ways. For instance, in various different investigations that we handle, there may be one person being the day-to-day quarterback, but then when it really comes time to negotiate a settlement, we may bring someone else to kind of join that team. For instance, I tend to get more personally involved when it comes to negotiating the settlements because I've had more experience with that and a lot of success in that area, and that may not be the strong suit of the person that's running point on the day-to-day investigation. So utilize kind of the full skill set of everyone at your disposal, and don't just assume that the person that's running things on a day-to-day basis needs to take it all the way to the finish line.
Absolutely. And then finally, just to talk a little bit about the internal investigation, and Jamie's probably pleased to see at the very top of my list of things that reasons to do an internal investigation is the PR benefit. And again, as we've talked about before, having that credible third party doing that can really tip the scales to help you to do that. Employee officer interviews, again, just prepare as make sure you've got your facts in place before you do your interviews. If you're going to be doing internal interviews, perhaps you're going to have to turn over some folks to be interviewed by investigators. Make sure you've helped prepare them to make sure that they've got everything in place. Now, this does get back to your point before about who the lawyer represents. They may very well need their own counsel because they're targets themselves, because there's a conflict between their position and the organization's position. So make sure you've worked out through all of that. You don't want the organization's lawyer representing them if there's going to be a conflict there, and then you have privilege issues, you have all sorts of disqualification issues that can come into play. And then if things do go to a congressional hearing, I think this is probably the ultimate PR sort of nightmare. It's very rare that it turns out well, I would say, but it can. But a couple of things to think about is to make sure you're preparing the written testimony that goes in, that you have your lawyer there while you're writing it, as well as your PR team. I've had some of the most fun I've had is the sort of the collaborative process between the PR team and the legal team as you work through the written testimony, as you prepare the questions, as you do the mock question Q&A with the witness to get them ready to go, so that you've got the legally correct answer and the best PR answer that you can be prepared to give. Of course, the key of all when you're testifying before Congress, you've been sworn in, and so I have the only statutory reference in the entire presentation today. 18 U.S.C. 1001 is the false statement statute. That's what gets everybody. That's even if there's sort of no underlying crime, if you lied about it, that'll be what's on the indictment. So you've got to be very careful when you're answering questions to any agency or doing a hearing. And the key really here is to prepare. The people who have prepared do tend to fare better in the congressional hearings. Doing the murder board beforehand, where you've got people who actually know the kind of questions, have experience on the Hill, can really ask the penetrating questions and be ready with the quick answer, makes a tremendous difference for actually appearing before Congress. So thank you very much.
Thank you, Ron, and thanks to Jamie and Kathy as well. Fortunately, we're out of time. If any of you have any questions, feel free to email or call any of the speakers directly or myself. You'll see on the last slide links to some additional resources on these topics and others on our website and our nonprofit YouTube channel. Thanks very much for coming and participating. We hope to see you back here next month. Thank you.